Hi, Dennis Brislawn from Brislawn Lofton, attorneys at law, Kirkland, Washington. You know, it's gratifying to have been a number of people's attorney for decades now. I think I'm in my 23rd year of practice. I've gotten to work with a lot of attorneys and a lot of people. But it's really hard when I get a phone call from a family member that says, Dennis, I just lost my dad, or my mom passed, or my brother or my sister. We've even had some very difficult situations where a child passed away. One of the features of being an estate planning lawyer that my partner Tom and I treasure is that we have an opportunity to help people work through things, and working through them can take some of the grief and pressure away. So I know that when you lose a loved one, that it's traumatic, it's often sudden, but even if you saw it coming, that doesn't necessarily make it easier. What does seem to help is to have some busy hands. So estate settlement is about the process of administering a deceased person's affairs. Essentially, we do an inventory. We figure out what did they own, what stuff did they have. We put a number on it of some kind, either very scientifically or sometimes a scientific wild guess. We do the same thing with debts. We inventory debts. And we create a process by which we start moving through what a person has collected in their life, what they own, what obligations they have to others, and then we look to their estate plan. Hopefully they have a written plan in the form of a will or a living trust. But whatever the controlling mechanisms are, we read those, and we, on our side as the lawyer side, we try to do risk reduction. We try to lessen taxes. We try to lessen the opportunities for beneficiaries to go sideways. More about that in a moment. But at the end of the day, we know what the governing documents say, if there are any. If there are no governing documents, we know what the laws say that the court will impose. We know who the beneficiaries are, and we can work up a plan to get things taken care of. Now, some clients have a continuing desire. They want to continue to control. That's where trusts come into play. You see, whether you create a trust during your life or you create a trust in a will at death, the purpose of a trust is to be a benefits book for people or causes that you selected and where you wrote down what will happen. So in settlement, it isn't always pay the bills, pay the taxes, divvy up the money, and we're done. Sometimes in settlement, we have to continue on. We may continue on because there's a beneficiary who's underage, or we may continue on because you laid down a trust that is going to continue to provide benefits for one person, a group of people, a charity, or even Muffy and Fluffy, your puppy dog and kitty cat. Believe it or not, you can do that. I mentioned a little bit about people going sideways. What do you think the two things are that cause more agony and more litigation in an estate? Now, if you said personal property, you're right. If you said cash, you're right. Those are the two things that seem to make a lot of family members crazy. How do you deal with it? Most states allow, through a will or through a living trust, they allow you to write a tangible personal property memorandum directing where personal items will go. So I'm talking about things you can touch, like this chair arm here, if you can see it or hear it. I'm pounding on it. That's a piece of tangible personal property. Washington State lets me state in my will or trust, I authorize myself, Dennis, to write a personal property memorandum and change it whenever I want. That's pretty neat because you don't need to go back to your lawyer to change your mind. But it does mean that you have to write things down in the proper way so that the rest of us know that there is a binding instruction about who gets grandfather clock. Don't use stickers. Many clients use stickers. Stickers have a way of coming off. You really want to do this as a formal part of your estate plan. Talk to your lawyer about it. Another item that makes people go sideways is a failure to recognize the lack of, let's say, dependability in being a fiduciary. You pick somebody to be your agent under a power of attorney, or you pick somebody to be your personal representative under a will, or you pick somebody to be a trustee of a trust. What if you pick all of your children to collectively be the trustee of your trust? Folks, what I'm sharing with you is that you really need to think these things through and stress test them in a discussion with your attorney. If you're married, there's a good chance that you and your spouse can figure this out and create a workable system. But my experience is that many people do things because they think they should out of some sense of fairness, and they trap themselves. They build a system that just won't work. If you have 7 kids, do they really get along all that well all the time? By the way, Americans are reluctant to hire help. Somehow we think that it's going to be cheaper or better if we do it ourselves. Is that really true? How many of us could get under the hood of our car these days without having an auto mechanic who is a computer technician? I know I couldn't. I can put some fluids in there and I've just about maxed out my capability. So there is a time and a place to ask for help or to interview for help. And the time and place to do it is right now while you're healthy, not to visit that upon other people if you're in a coma or you have died. The chances of things being fixed at that point are low. You're the best person to fix things. So, settlement of an estate or administration of a trust is a process. The better organized you are, the less expensive it will be. But I do think that if you have a good plan and you keep it updated and you're somewhat organized, the chances that your estate will be properly handled in the event of an emergency, that you are sick and incapable or you die, are going to be dramatically better. If you have a team that you work with in your law firm, if you have people that you know have your back, if you occasionally catch up with them, things will be less expensive and will work far better. I guess in short, I want to share with you my utmost belief that a good estate administration or a good trust administration is based on a relationship between the client, the people they pick to run things, and the professionals that they call upon to help them. Typically it'll be a CPA, an attorney, and a financial planner. But you may have 2 of the 3 or 1 of the 3 and not all of them. It's really up to you. I'm Dennis Brislawn from Brislawn Lofton. These are some thoughts about estate settlement and trust administration. Call us if you need us.